Thank you, everybody, for coming. Deeply appreciate this. This is part of what I am attempting to do every year during Constitution Week, present this Constitution 101. There are many great programs, such as Hillsdale College's Constitution 101, Rick Green's course, that are deeper dives, and as we'll be showing you here, Liberty Lane, which we're doing with Susan Hamilton here locally, the second installment of which is coming up soon. Tonight is meant to be a 30,000-foot view, a primer to the Constitution to kind of whet your appetite and make you want to learn more. So my name is Shelby Williams. I have the privilege of serving on Plano City Council. I'm the former Texas State Director of Convention of States. The first question we have to ask is, why is the Constitution important? Take yourself back 250 years to what the colonists in America were living in. The original pilgrims had come here seeking religious liberty. There's a reason that freedom to worship is the very first clause of the very first amendment to the Constitution. At the time, and we'll go into this when we get to the First Amendment, but religious loyalties were fractured and there was a lot of blurred lines between the church and the state. So the phrase you're probably familiar with is separation of church and state. You may be surprised to learn that is nowhere in the Constitution. That was written in a letter by Thomas Jefferson to the Danbury Baptist Association many years after the Constitution was ratified, and it was taken out of context from the letter for those who want to claim what it means, but it was meant to discuss the whole reason for the structure of the Constitution and the First Amendment. So we'll delve into that as well. But that little nugget, that the separation of church and state appears nowhere in the Constitution, is one of the things I was speaking a little bit about before the presentation that made me question what else I thought I knew about the Constitution. And there's a ton. So the question I was asked earlier is, when did I start studying the Constitution? I was probably in my mid-20s. I think like most of us, we had gone through school reading it, checking the homework box, moving on, and not really understanding why it's important. So the central reason why it's important is, and our founders understood this a lot better than we do today, there is a lot of the Word of God and Judeo-Christian principles infused in the Constitution, but they understood very well that man has been a terrible steward for God's law. And as long as man is governing man, the Constitution and the freedoms encapsulated therein and the restraints on government are mankind's best hope to avoid tyranny. A lot of tyranny has been wrought in history, is being wrought today in the name of religion. Well, is that truly God's work or man's work? The Constitution draws that demarcation to say, whatever you may claim you're doing in the name of God, this is what will govern you. And therefore the Constitution, as enumerated in Article 6, is the supreme law of the land. So going along with this, I talked about some of the things that we'll go into a bit deeper dive in the Constitution. One of those is Liberty Lane. This is being hosted by my friend Susan Hamilton here, kneeling in the front row, who is live streaming this for me. We had the first run of this in which I was privileged to participate. It encompassed several weeks. There was a different episode every week talking about a different section of the Constitution. Please check out OBBM, that's Offbeat Business Media. This is going to be a recurring series, and there will be a new segment every week. So the beginning of the Constitution, the preamble, as it's called. We're going to spend a little bit of time on this because it's not just some flowery words. The structure is important. So we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, which doesn't mean what it means today, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. We got to break this down a little bit. We, the people, that's who's establishing the compact. The Constitution is a compact, kind of like the Mayflower Compact, but much more enduring. The compact is not between, remember these were, at the time the Constitution was written, America had already won its independence. The Articles of Confederation were in place to structure the new government. They were ultimately deemed to be very flawed, and there was a convention convened amongst the states called the Annapolis Convention, where they determined this thing's got problems, y'all. We need to convene a new convention for the purpose, and I quote, of rendering the Constitution of the federal government adequate to the exigencies of the Union. In layman's terms, that means fix this thing. So that's a pretty broad mandate, though. Render the Constitution of the federal government. Not render the Articles of Incorporation adequate. Render the Constitution, meaning the makeup, the structure. So it's a completely broad mandate set by the Annapolis Convention to fix all the issues that the fledgling republic was having. Now, these were states convened at the Constitutional Convention in Philadelphia, called by the Annapolis Convention. They were already states. It did not say, we the United States. It did not say, we Benjamin Franklin et al. It said, we the people. This is the first phrase of the Constitution for a reason, because that's who's establishing the compact. And that goes straight back to something we'll see in a moment here, which is lifted directly from the thoughts penned by Thomas Jefferson in the Declaration of Independence. It's a fundamental precept in the Constitution and our entire form of government. So, establish a more perfect union. What does more perfect mean? Isn't perfect already perfect? How can you make something more perfect? You can't, not if it's truly perfect. What this meant is we know we are always going to fall short of perfection. The purpose of this Constitution is to give ourselves the chance to continually strive toward perfection, to create a structure whereby that is always incentivized, because we will always fall short of absolute perfection. Establish justice, that's more self-evident. Domestic tranquility means peace. One of the precepts, again, of government in general, and the purpose of government is to prevent human beings from preying on one another. That's the whole purpose of government, at least at the federal level. Provide for the common defense, same principle. Promote the general welfare is the phrase. Back in the day, 250 some odd years ago, welfare did not mean what it means today. Welfare meant general well-being, which is why I said general well-being in that bullet point. And secure the blessings of liberty to ourselves and our posterity. So you said freedom was what they were after, absolutely. And they wanted to try to secure that freedom and safeguard it for and against future generations as best they could. So that's the preamble. So we're going to review a lot of things tonight. You think, well, we don't do that. Well, this happens every day. That's blatantly unconstitutional. Why? Here's the reason. This is a pocket constitution. This is what was actually penned by the founding fathers, the framers, including all the amendments, only 27 amendments to date. As a bonus, the Declaration of Independence is even in this little pamphlet. This giant monstrosity is the annotated Constitution of the United States. We call it CONAN for short, Constitution Annotated, CONAN, big, heavy, barbaric behemoth. This is the Constitution as interpreted by now nearly a quarter millennium of Supreme Court jurisprudence. This is 9 currently, previously fewer people in black robes telling you what all this meant. Well, I'm not a constitutional law professor. I'm not a constitutional attorney, and that's kind of the point of this whole presentation. You don't have to be. All it takes is a desire to learn, an understanding of English, because this Constitution was written in plain English. That English is a little bit antiquated now, but it was still plain English. It was meant for we, the people, to read and understand. So it doesn't take a rocket scientist, and it doesn't take a Supreme Court justice to understand it for you. Now, there have been numerous Supreme Court decisions passed down through the past quarter millennium. Some of them are egregious. Dred Scott stands out. There are more modern egregious decisions. But the point of all this is nobody gifted Supreme Court justices with omnipotence or righteousness. They are just people. And they're lawyers. Not to dig too hard on lawyers, but just saying. So this is a screenshot. You see the coffee cup, Convention of States. Convention of States is the organization I had the privilege of being Texas State Director for a couple of years before I stepped down last year to try to amend the Constitution through Article 5 of the Constitution, which is the amendment process. We'll go into that. So this is the underpinning. This is the philosophy upon which the Constitution was built. So the Declaration of Independence, most of it covers all the grievances that the colonists had against the King of England. But there are some very important tenets in here. We hold these truths to be self-evident, that all men are created equal. This is probably the part you're very familiar with. That they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That's probably where what you heard in school stops. And that to secure these rights, governments are instituted among men, the whole purpose of government, according to our founders, deriving their just powers from the consent of the governed. That takes us straight to the concept of a compact, where our framers and the founders who passed this, the difference between the framers and the framers wrote the Constitution, the founders passed it. They are encapsulating this thought about the whole purpose of government. It's to secure these natural rights. These natural rights come from God, are endowed by their Creator. They don't come from government. Government cannot government cannot grant you rights. The Constitution does not grant us rights. It only recognizes them and protects them. By the same token, the government cannot take away your rights. It can only violate them. Hence, with that understanding in mind, the purpose of government, we have the three branches. Everybody learns this in grade school, or at least middle school. We've got the legislative, the executive, and the judicial. And in the Constitution, they appear in that order for a reason. First is the legislative that makes the laws. Now, that's a key concept. We don't see a whole lot of that anymore. At least at the federal level, the Congress, which is comprised of the Senate and the House of Representatives, that's the whole Congress, they pass a bunch of stuff, and then they kick it over to the executive branch to figure out how it works. So that's not actually making laws, that's just delegating to the executive. The executive's role under Article 2 of the Constitution was to simply enforce the laws, to take the laws passed by Congress, which were very limited, by the way. The purview that Congress had, as we'll see, to pass laws was very limited in scope. The executive was supposed to apply those and had certain plenary powers, things that were applicable to the executive that it didn't need permission for. But there were checks and balances. Probably the most familiar is that the president, as the executive, is the commander-in-chief of the armed forces. However, only the Congress has the power to declare war. That was thrown out the window a long time ago. And then lastly, the judicial branch is to interpret the law. Now, that doesn't mean to interpret what the Constitution says. We're going to walk through it here. You tell me if you find any of this confusing. We don't need the Supreme Court to interpret the Constitution for us. What we do need the Supreme Court to do is to apply common law and conflict, and in fact, adjudicate conflict. In fact, the Supreme Court has a special scenario where it's the court of original jurisdiction, meaning cases originate in that court. They don't just get appealed to the Supreme Court. So Article 1, Congress. It starts with this: because all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So those are the people that are supposed to be closest to we the people, the Senate and the House of Representatives. I know my congressman. I can reach out to my congressman. Our senators, on the other hand, are a little more unreachable. That's due to the 17th Amendment, which we'll also cover later. But that accountability to reach out to your local elected officials and your congressmen because they are local was meant to be part of the system. It's so I have a local throat to choke. The president, which most people are never going to see, let alone meet, let alone be able to have their cell phone number and say, hey, what are you thinking? The president's very out of reach, even when we only had 13 states. So that's why all the legislative power, which just means making what the laws are, is supposed to be in the Congress. Now, you may have heard the phrase enumerated powers. That just means specifically defined powers. Congress has a very limited scope, as we discussed earlier. And we're going to go over all of these. Some of them are more interesting than others, but the point of my including all of them is so you can see right here in the course of a short presentation just how few there are. So regarding financial powers, lay and collect taxes and tariffs. So if we want to slap a big tariff on China, guess what? That's not the president's purview. It's Congress's, but they have the power to do it. Borrow money, which we do ceaselessly. They're going to raise the debt ceiling again. They're going to borrow money. Coin money. In the fledgling republic, we didn't actually have a federal currency. Every state had their own currency. Regulatory powers of Congress. This is going to be key. Regulate commerce with foreign nations, England, France, and native tribes, because they weren't officially part of the United States, and among the states. Among the several states is the phrasing in the Constitution. You can look it up. It's right there in Article 1. This changed in 1942, which is what really turned the federal government upside down. Even though World War II was raging in 1941, what America looked like from a governmental and a regulatory structure in 1941 before this happened was nothing like we know today, but we've all grown up with it. We don't know anything else. We don't know anything different. What happened in 1942 was a landmark Supreme Court case, Wickard v. Filburn. Now, commerce among the states. What was meant by this was that the federal government had the power to regulate commerce between states. The intent of this was so that South Carolina couldn't slap a tariff on goods imported from North Carolina. That's it. So it's basically daddy moderating amongst the children, except the federal government in this case wasn't meant to be daddy to begin with. So the Wickard v. Filburn case, there were quotas at the time on reverse quotas, caps on how much wheat you could grow. It's perverse, but it was in place. So this case held that the Secretary of Agriculture, and hence the US federal government, could regulate a farmer in, I think it was Iowa, who was growing crops above the quota, but not for sale on the market, just to feed to his own animals. He was growing extra crops above what was allowed. Shouldn't have been capped to begin with, but that's neither here nor there. The Supreme Court's reasoning, when we talk about egregious Supreme Court decisions, this is one. The Supreme Court's reasoning was that why he should be subject to federal regulation for just growing food on his own land to feed his own animals was because by withholding that from the market and by growing food for his own animals when he otherwise would have had to purchase the crop on the market, he was affecting interstate commerce and therefore was legitimately subject to federal regulation under the Commerce Clause right there. Ask yourself if there is anything in life you do that does not affect commerce. If I choose to sleep in an hour late, it's going to affect commerce because I'm going to have one fewer productive hours today to work. Everything affects commerce. This is what opened the floodgates to federal overreach, but now it was legitimized. And the question you have to ask yourself is, with all these enumerated powers, is if the Commerce Clause meant originally that you could just do anything you want anyway, why go through the trouble to enumerate all these other things? They're going to fall right under that, such as establishing a uniform rule of naturalization, citizenship, and laws on the subject of bankruptcies. How does bankruptcy not fall under the concept of commerce and finance? Of course it does. So we know from many sources and applications up until the Wickard v. Filburn decision that the Commerce Clause never meant what that Supreme Court said it meant. But this was one of the examples of a Supreme Court decision which opened a whole avenue of practice, of federal government regulation, which was never intended. And it also created unaccountable action because the bureaucracy is really where things are run. The legislature passes such nebulous bills for the bureaucracy to figure out for a reason, because they're then not accountable. Yeah, we passed that bill, but everybody said it was a good idea. Blame the department of such and such for defining the regulations in a way that hurts you. Not my fault. Yeah, it's your fault because you abdicated your responsibility under the Constitution, which you swore an oath to uphold. All elected officials do at every level. Provide the punishment of counterfeiters. Pretty obvious. Good sense. Establish post offices and roads. Now, it's important to note, this does not require post offices. I think it was probably a good idea back in the day. I think it's needless now and it's a waste. We have much more efficient ways of dealing with that through the market. So this does not require a post office, it just authorizes it. So as bad an idea as I think the current post office is, it's still legitimately authorized under the Constitution. Patents, good idea, unless you're China, yeah? Create courts inferior to the Supreme Court. So note, the Supreme Court is Article 3 of the Constitution. It's got its whole own article. It's very special. Congress is the one with power to create inferior courts, not the Supreme Court. Checks and balances. Protective powers of Congress. Provide for the common defense, create a military, and general well-being. Again, this said general welfare. I changed the wording to general well-being to better convey what it would actually mean in today's terms, because welfare at the time did not mean government handouts or subsidies. Organize, arm, and discipline the militia and call forth the militia. Pop quiz. Who's the militia? People. That's right. It's just the people. You know, we didn't have a lot of interstate commerce at the time. You know, small villages, no internet, didn't even have locomotives then. So most things were local, but the militia was just the able-bodied men. So to organize, arm, and discipline the militia, that means if you're going to call forth the militia, then you better equip them. They're not just supposed to be cannon fodder. Literally, cannon fodder. Make rules for the government and regulation of the land and naval forces, military, again. Raise and support armies, provide and maintain navy. Remember, at the time, there was no standing army in the United States. Armies were raised based on need. The world changed, of course, but it is still within the power of Congress to do so, whether it's for a specific time period or in perpetuity. Declare war, that's the big one. Now there are, dating back to when the Constitution was ratified, there have been skirmishes that didn't require a declaration of war for defense. In fact, there was all sorts of stuff going on with the Barbary pirates back in the day. And actual declarations of war were pretty serious, but still under the purview of Congress. President could not just unilaterally start actually making war, but that is a different matter, definitionally, than skirmishes, including border skirmishes. Define and punish felonies on the high seas, the Barbary pirates, and offenses against the law of nations, and make rules concerning captures. So the law of nations, that's not what we would call international law today. You know, nobody's being tried at The Hague. I should say that there is no such thing as international law. Like, we, at least the United States, has not said, yes, we subscribe to this. So nobody can impose international law on us. The only law that you can apply, whether locally or internationally, is that which you can actually manage to impose. The Constitution is what gives our entire government the basis for the authority to do so under that compact. If France or South Africa or Chile doesn't like what they're doing, they can't impose anything on us, unless we let them. Legislative powers of Congress make all, there's that word again, all laws necessary and proper for carrying into execution the foregoing powers. If I could get just one amendment to the Constitution, this necessary and proper clause, I would clarify the Commerce Clause, as we discussed in Wickard v. Filburn, in conjunction with the necessary and proper clause once and for all. This has been interpreted, or misinterpreted, I should say, to allow anything and everything toward the furtherment of what would be nice. That is not what the Constitution is for, and it's not what government is for under the premise that government exists to secure our rights. And again, secure our rights, not grant our rights. Okay, now it goes through powers forbidden Congress, like explicitly, don't touch this. Deny a state the right to admit migrants or immigrants until 1808. So obviously that doesn't apply now, but like I said, I wanted to include everything to give you an idea of the very limited scope that it had. Suspend habeas corpus, that's the right to trial and everything. You can't just detain somebody indefinitely for no reason. So Congress could not suspend habeas corpus except in time of rebellion or invasion. Pass a bill of attainder, it's a declaration of guilt by a legislative body. So if you're going to be found guilty of something, it's got to be by an actual court under the rule of law. It can't just be the Texas legislature finding Shelby guilty of whatever. Though they might, who knows. No head or direct tax. $10 to you, $10 to you, $10 to you. Of course, that was much more money back then, but still, forbidden. Draw from the Treasury without an appropriation bill. So we have the Treasury, basically the bank account for the United States, and to appropriate, we hear about appropriations in Congress. Congress has to actually pass and authorize what it's going to spend. So you can't just draw that money without due appropriations. That's it. We're on to the presidency, Article 2. That's all Congress is allowed to do. Now we'll get through the presidency, and you tell me if you think the scope of the federal government has increased significantly. So Article 2, the presidency, there's a reason the legislature came first before the presidency. The president was not supposed to be this omnipotent God king. It wasn't supposed to be the end-all, be-all of electoral America. Ben Shapiro puts this my favorite way. He said he wants the president to be like his plumber. Just make things work. Just make the government work and then stay out of my way. The executive power shall be vested in a president of the United States of America. Presidential powers. Commander-in-chief of troops called into the actual service, that's the quote, of the United States. Make treaties. So the president and the executive does have the power to make treaties. This is separate from Congress's power to declare war. Nominate ambassadors, public ministers and consuls, federal judges, and other officers established by law. So all the attention goes on the Supreme Court nominees, but the president appoints, or nominates at least, a lot of lesser judges to the federal courts. And there are a ton of federal courts these days. See Wickard v. Filburn. But the president only has the power to nominate with the advice and consent of the Senate. The president can nominate anybody he or she chooses. Only the Senate can confirm. Fill up vacancies during a Senate recess. So if the Senate is recessed and there's a legitimate vacancy, we've seen this abused, then the president can make interim appointments. Reprieve and pardon, that's like the farewell from every president leaving office is to pardon a bunch of people. And the veto power. Of course, there's no line item veto at the presidential level. It's just lock, stock, and barrel, so stop sending these omnibus bills or I'm going to veto the whole thing. That's it. That's the president. Anything strike you as odd today, given what we just reviewed? And again, I included everything except I didn't just reproduce the entire Constitution, but that had all of the things that were allowed to both the Congress and the president, so you get an idea of just how limited this was supposed to be. Nothing in there about executive orders if you think it's a good idea, or if these people like it, or if there's this danger or that circumstance. That's it. That's the federal government. Why is that? Because the founders wanted chaos, wanted no effective control of the government. I mean, it's supposed to secure our rights, so why didn't they get the tools to do so? Because as we'll see in the 10th Amendment, the overwhelming majority of governmental power was meant to be vested in the states and in the local government and in the people. So the states came together and created the federal government through the Constitution. That's what this is. This doesn't tell any of the states how to run themselves. That's why every state has its own constitution, because it's up to the state to determine how to run. Well, isn't that inefficient? Yes, but it's also the best safeguard for our freedom. Centralized control, as we've seen everywhere in the world and in history that it's been done, crushes liberty every single time. It's because humankind is humankind. And humankind in government is no exception. In fact, it's twice as applicable. Which takes us to Article 3, the Supreme Court. The judicial power of the United States, the federal government, not of everybody everywhere, shall be vested in one Supreme Court and in such inferior courts as the Congress, remember, may from time to time ordain and establish. So this is what the Supreme Court can do, judicial powers. All cases in law and equity arising under the Constitution, so constitutional law, the laws and treaties of the U.S. Made under their authority. So laws made under the authority of the Constitution by Congress and duly signed into law by the President, treaties made can be arbitrated by the Supreme Court. All cases of admiralty and maritime jurisdiction, it's outside of what normal people are doing on land. Controversies to which the U.S. is a party. So that's not just between countries, that could be the United States, or that could be Wickard v. Filburn, good example. That was the United States as the Department of Agriculture and this farmer. Controversies between two or more states or citizens of different states. So I'm a citizen of Texas. If I've got a beef with my friend in New York, what court is that arbitrated in? It's supposed to be the federal court. Now, Supreme Court wouldn't necessarily take this up directly. That would go to an inferior court, a federal court. But controversies between two or more states. If Texas and Oklahoma are jawing at each other over the Red River rivalry, then the Supreme Court has jurisdiction. Controversies between citizens and a foreign nation. Strike anybody as odd in terms of what we see today? So let's say the foreign nation is France. Why would the Supreme Court deal with that? Why not the president? Why not Congress? Checks and balances. President can make treaties with France. President doesn't have power under this to throw me under the bus in order to appease France. That's the Supreme Court's place, to throw me under the bus to appease France. In all cases affecting ambassadors, public ministers and consuls, the states and states, Supreme Court of the United States, SCOTUS, has original jurisdiction. That just means that's where the case originates. In other cases, all other cases, SCOTUS has appellate jurisdiction. So it could start in just a minor federal court and be elevated to the Supreme Court. A lot of cases get appealed to the Supreme Court for a final ruling. That's just what appellate means. That's it. That's the Supreme Court, okay? We've just looked at the entire federal government structure, legislative, executive, and judicial. Think to yourself just about all of the stuff you've heard out of the federal government doing over the past year and ask where in all of that did they get that authority from? The answer is they didn't. So now, Articles 4, 5, 6, and the amendments and everything, those, we're going to go over all of that, but they define various things under the government, not the structure of government, not what they can do, other than amendments limit their power. But this has to do with states and citizenship. So full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. That means that Oklahoma has to honor a Texas driver's license. Basically what that means. That could apply in any number of ways, but that's the principle. So at the time in the Articles of Confederation, and this is the whole reason the Annapolis Convention said, you need to fix this. The Articles of Confederation were very deficient, and the central government, as it was called, had almost no power. Like a lot less than was even given to it by this. In fact, in addition to reading the Constitution, read not only the Federalist Papers, which many of you may be familiar with, but the Anti-Federalist Papers. So these were literally papers that were written and published in newspapers around the country during the time of the ratification conventions. The Federalists were arguing in favor of the Constitution as it was passed out of convention. The Anti-Federalists were saying, hey, this is going to give the federal government too much power, guys. Lo and behold, they were right. I don't know that there would have been any avoiding it in either case, and if the Anti-Federalists had their way, we probably would have had whole other deficiencies, but there are mechanisms in here to restore all of this, which we'll go into. But this is what this basically means. A driver's license in Texas is valid in Oklahoma. Okay, Article 5, amendments. This is how you amend the Constitution. How many of you have ever heard the phrase living Constitution or living, breathing Constitution? Raise your hand. Yeah, no such thing. The Constitution was written with an amendment process because the framers recognized the need to change it with changing circumstances, with a changing world in the future. That's what this is about. It was never intended for the Supreme Court to just reinterpret it, giving whatever's happening in the world at the time. It was always meant to be a rigid structure that could be changed if necessary, and there's a very high bar to changing it. So the Congress, Senate and House of Representatives, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution. Or on the application of the legislature, this is the only way it's ever been done, through Congress. Congress proposes amendments. If 2/3 of each branch, Senate and House, pass it, then it goes to the states for ratification. The alternative method, which is what we're trying to do with Convention of States, is, and this is the way to end run Congress in this, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. So if 2/3 of the states apply, Congress calls the convention. It only has the ability to name the time and the place. The states send delegates, representatives to the convention, and they debate, argue, have happy hour, whatever they're going to do, and they propose amendments, which in either case, whether it's through Congress or a convention, shall be valid to all intents and purposes as part of this Constitution. They'll be adopted when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof. So either the legislatures or each state calls a ratification convention, as the one or the other mode of ratification may be proposed by Congress. That gives Congress the power to determine how any individual amendment is going to be ratified. So let's say we get the convention of the states. Let's say 10 solid amendments are proposed. You're going to clarify the Commerce Clause and undo Wickard v. Filburn. You're going to clarify the Necessary and Proper Clause. You're going to do a whole bunch of other good stuff. Congress can pick and choose and say, okay, that amendment's going to have to be ratified by state legislatures. That one is going to have to go to state conventions. That one too. That one we'll send to the legislatures. Now, this is a check and a balance. Obviously, Congress is going to pick the method of ratification which will least likely restrict its own power. But this is the whole system of checks and balances built into this. Now, it's worth noting there are 27 amendments to the Constitution. 11 of them were proposed right up front, almost at the very beginning. 10 are in the Bill of Rights, and one of them wasn't passed until a couple of centuries later. Ratified until a couple of centuries later. There were 12 originally proposed with the Bill of Rights. Only 10 of them passed ratification at that time to become what we know as the Bill of Rights, the first 10 amendments. And then one of those, the 11th, might have been the 12th at the time, but still, it's the only one of the extra two that ultimately got passed. Over 5,000 amendments have been proposed in our nation's history. Only 27 of them made the cut. It is an incredibly high bar. Likewise, why haven't we had a convention yet? It requires 2/3 of the states, and there have been over 700 applications passed by state legislatures for a convention in our nation's history, but never 2/3 on the same subject matter. They can't just say, well, we want a convention. Sounds like a good idea. It's got to be on a subject matter. Some resolutions are passed for specific amendments, like the balanced budget amendment, and it's got all the wording and everything. We want this amendment in a convention. I don't see the point in a convention for a fully baked amendment, but still, that's done. Convention of States proposes subject matter to allow for the deliberative power of a convention. There's 3 tiers to it. It's limit the power and jurisdiction of the federal government, impose fiscal restraints on the federal government, and limit the terms of office for federal officials and members of Congress, which can include Supreme Court justices. But it's also worth noting that the Bill of Rights itself came about because of pressure under the Article 5 movement for calling a convention. So when the Constitution was finally ratified, the Constitution that came out of Constitution Hall in Philadelphia, a lot of the states, because all the states had their own conventions to debate this. That's why the Federalist and the Anti-Federalist papers were produced, was to try to convince the delegates and the people to pass or not pass this. So it was debated, and a lot of states had concerns about why specific rights, like the freedom of speech, freedom of religion, et cetera, weren't contained in the original draft of the Constitution. And they were legitimate concerns. So the advocates for passing the Constitution said, pass it and we'll amend it. Once the new Congress convenes, we'll pass amendments to secure those rights. So the Constitution was ratified, the new Congress convened. Guess what it did? Same thing Congress has done ever since, sit on its hands. And people were like, well, you promised this, where is it? Well, it's coming, it's coming. And so the states said, nuts to this, we're going to do it ourselves. And so they started passing these state resolutions to convene a convention. And then after enough momentum built up, Congress is like, all right, I get the picture. And they went ahead and proposed the amendments between the House and the Senate, and then they came up with the Bill of Rights +2 and sent those out to the states for ratification. Article 6, supremacy. So we say the Constitution and the laws of the United States, which shall be made in pursuance thereof. Not just any old law somebody thinks is a good idea, but the laws which are passed in pursuance to the Constitution. And all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. There is nothing higher which governs us governmentally. Now, my personal priorities are God, family, country, and then party. But like I said, as long as humans are left to govern humans, humans have been terrible stewards of God's law. So that is the supreme law of the land. Nobody gets their way over the Constitution. And the judges in every state shall be bound thereby. You have to abide by this. And anything in the Constitution or laws of any state to the contrary notwithstanding. Like, this is it. So the senators and representatives, before mentioned, and the members of the several state legislatures. These are the people in Austin. And all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation. Everybody in an elective office, at least according to the Constitution, I don't have to as a city councilman, but I did anyway. I think that's actually in the Texas Constitution, so it delegated. But shall be bound by oath or affirmation to support this Constitution. Okay? If we are going to take up that mantle as an elective officer in the United States, we have to take that oath to protect this because, and this is why. This represents the rule of law. If we don't have the rule of law, if we just give short shrift to the principle of the rule of law, what we have literally is might makes right. If you've heard that phrase, that's how the world used to be governed, which is whichever warlord can conquer the most land and subject the most people, he wins, right? Well, today, at least in most parts of the world. It's not governed by warlords anymore. It still is in some parts, like Somalia, but it's governed by influence. Whoever can wield the most influence gets their way. That is completely antithetical to the concept of the Constitution and the rule of law. If enough people genuinely think something is a good idea, there's a legal process which they can go through to make it happen. But just imposing their way or finding a court that'll rule in their favor ain't it. But no religious test shall ever be required as to qualification of any office or public trust under the United States. So this has gone back and forth a little bit recently, but consider what the arguments were like back at the founding. You know, you've got various denominations of Christianity. Let's say you've got Anglicans and Quakers. They do not want one another running things, which is part of the reason for the Constitution. Today, there are a lot of people who are suggesting that Christians should just not hold public office because of the separation of church and state. It flies in its face, and it's completely violative of that principle. Okay, so Article 7, ratification. Pretty simple, but it had to be baked in there. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. So, remember there were 13 colonies. There were 13 states in this originally. The Constitution said that only 9 of them were necessary to ratify. That didn't mean they were going to drag the other states into it, whether they wanted to or not. It's just among the ones that did ratify. As it happens, all of them ratified. Okay, that's the entire Constitution as it was originally penned. Now we're moving on to the Bill of Rights. First Amendment, familiar to everybody. Not so familiar to CNN hosts. I don't think they really understand it very well. Congress shall make no law respecting. This doesn't mean showing favoritism to, it means regarding an establishment of religion or prohibiting the free exercise thereof. To understand this properly, you have to take yourself back in the context of the day. And the whole reason that the Pilgrims came here to begin with, in England, the church and the state were the same thing. The Church of England was the religious authority in England. That's why people fled to worship to the dictates of their conscience. That's why they fled England. So the clergy in England had actual legislative power in the Parliament. That's what this is about. It says, everybody in America is free to worship to the dictates of their conscience, and nobody can prohibit that. That's it. The notion of separation of church and state does not mean that religion or Judeo-Christian principles have no place in government or in elected officials. It means that the government shall not make edicts, religious edicts, basically. The government shall not make religious edicts, which is exactly what was happening in England at this time. That's what it means. Or abridging the freedom of speech or of the press. This is something that gets twisted a lot. So freedom of speech applies to the government, as enumerated in the Constitution. The principle of the freedom of speech applies to anybody and everybody. So the government cannot silence you for your opinion. If your employer wants to silence you, that's their purview. You might want to find another employer. But you're not protected under the Constitution from having your employer silence you. Just important distinction. And the right of the people to peaceably assemble with or without a pandemic. There were pandemics here. Smallpox was a big thing at this time, so it's not like they never foresaw this. They absolutely foresaw this. They were living in it. The right of the people to peaceably assemble and to petition the government for a redress of grievances. Key word there, peaceably. And petition the government for a redress of grievances. That simply means, again, a bit antiquated language, but it's still plain English. It just means, just as the King of England was oppressing the colonists, we find what you're doing to be oppressive and we want resolution. Second Amendment, the right to bear arms. A well-regulated militia. So we already covered what militia means, just the able-bodied people. Anybody want to take a stab at what well-regulated means? I know you know, but go ahead. Go ahead.
Good working order.
That's right, good working order. I'd highly recommend you download the app. I think it's the 1828 dictionary. It's a dictionary from 1828. It shows you what words meant then. And well-regulated, there's plenty of historical evidence for this. Well-regulated at the time just meant competently functioning, in good working order. It means having the people around your village or town knowing what they're doing. A well-regulated militia being necessary to the security of a free state. Remember, they just fought a revolution against England. There was still a lot of tension. The War of 1812 was to come, still with England. They were every bit as mindful of security of a free state. Notice the word free here. Not the security of these United States, the security of a free state. They were mindful that security of a free state could mean against outside invaders as well as internal tyrants and an oppressive government. That's what they had just freed themselves from. And they knew that whenever people were disarmed, that was license for the government to become oppressive. Just look what's happening in Australia right now. If you have not been paying attention, the whole country is on like literal lockdown. People are being jailed just for leaving their homes without, quote, a viable excuse. What happened in Australia a decade or so ago? That's right, complete public disarmament. Anybody, we want to avoid violence at all costs, but anybody will think twice when they're looking down the business end of a firearm. Anybody will. If a people is disarmed, there is nothing stopping the government. They have no need to care. If a people is armed, they want to avoid that conflict. They want to avoid that violence wherever possible, as do we, and we should. You know, what sets our modern world, at least our world in the United States, apart from most nations in the history of the world is we're not constantly slaughtering one another. That was the story of the world for most of human history. This Constitution set the stage on the world stage to end that. We really, really want that. But if the bad people who will always exist until Christ reclaims his kingdom, if they're just going to do whatever they're capable of doing, what we allow them to do, then disarming the people is just opening the road to that. As I say, the Second Amendment is the only thing that stands in the way of all the other amendments. So you pray, it never has to be needed, but that's the only thing that's standing in the way. The right of the people to keep and bear arms shall not be infringed. So that's a definitive statement, shall not be infringed. They wrote it that way for a reason. This was providing the rationale for this whole amendment. It doesn't say that as long as there's a militia, then it shall not be infringed. It doesn't say that, well, it shall not be infringed as long as the federal government's regulating it. It says, shall not be infringed. There's no condition to this. This is the whereas clause. If you look at modern legislation, there's a bunch of whereases. Whereas we like this, we don't like that, etc. Then you have the actual meat of the law. And it says, this is what is the case. This phrase here, a well-regulated militia being necessary to the security of a free state, that's the whereas clause. The actual meat of this amendment is the right of the people to keep and bear arms shall not be infringed. That doesn't mean you're required to be armed, but it means you have the absolute constitutional right to be. Third Amendment, quartering of soldiers. Not so much an issue anymore, but hey, it's there in case we need it. So it simply says that no soldier in a time of peace shall be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So like even if we are in a state of war, like within the United States, you know, when we were at war with Japan in World War II, this didn't apply. You know, military couldn't come seize our homes just because here when everybody's off fighting in the Pacific Theater. So Likewise, even if we are in a state of war here in the United States, the military cannot just come barging into people's homes and do what they like. It's got to be in a manner prescribed by law. Fourth Amendment, search and seizure. Most people are familiar with this, but this has a lot of overarching considerations when it comes to operations of police, all sorts of federal agencies. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. What does unreasonable mean? It's a little bit subjective, but it's an important qualifier. Shall not be violated, and no warrants shall issue but upon probable cause. That guy looks kind of shady. That's not probable cause. And this was a big point of contention with the Patriot Act. Patriot Act was a ginormous bill, which nobody read, but passed because it had the word patriot in it. And it was, by and large, violative of the Fourth Amendment. The argument was made, well, but it's still a good idea because it'll prevent terrorist attacks. You might call it 6 of one, half a dozen of the other. You might prevent terrorist attacks and promote your own homegrown tyranny on the part of the government, because this was used to violate the property, liberty of several people who had nothing to do with terrorist organizations. So, in the name of security is a very fine line. So that's why this was meant to be restrictive. It's not like they didn't understand what saboteurs and even terrorists could do or were operating in. There was a lot of spies at this time within governments. They just didn't have all the fancy tech that we do now. Particularly the place to be searched and the persons or things to be seized. So that warrant and the probable cause, it's got to go through a process, it still does, however loosely it's sometimes applied to. You can't just go willy-nilly searching people. You can't just go randomly shaking people down. Fifth Amendment, due process. Everybody's pretty much familiar with the term, I plead the fifth, that's what it's about, but there are a lot of clauses in here. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, we get that a lot in the news, except in cases arising in the land or naval forces, military tribunals, when in actual service in time of war or public danger. This says if you're going to be tried for something really big, you need that indictment by a grand jury, okay? That grand jury has to evaluate the circumstantial evidence and say, yeah, there's enough here to even try this person in court. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So he's not going to be tried twice for the same thing. Note that this does not mean this is in jeopardy of life or limb, not money. Hence, O.J. Simpson was acquitted in his criminal trial, but he was convicted in his civil trial. He didn't have to serve any jail time in his civil trial, but he had to fork over a lot of cash. So there are two different areas of law. Nor shall be compelled in any criminal case to be a witness against himself. That's where the I plead the fifth comes in. Counsel has advised me not to answer that question on the grounds that it may incriminate me. Nor be deprived of life, liberty, or property without due process of law. So this applies to all areas. This is not just in the court. Notice this does not say in the court system. No person in any capacity shall be deprived of life, liberty, or property without due process of law. The laws that apply to eminent domain, for instance, that's where this comes in. Nor shall private property be taken for public use without just compensation. So if my land is going to be taken for eminent domain, both of these apply. I shall not be deprived of life, liberty, or property, and no property shall be taken for public use without just compensation. There are laws governing these things. Sixth Amendment, trial rights. This does have to do with courts. Fair and speedy trial. We're mostly familiar with this stuff, and there's not a lot of room for different interpretations, so we're going to skim past some of it. You have to be informed of the nature and cause of the accusation. You can't just be brought up to trial just because. We're not going to tell you why you're on trial. You're guilty. I know you are. To be confronted with the witnesses against him. No anonymous witnesses. You can have anonymous leakers all you want to the newspapers, but no anonymous witnesses in a trial. If somebody's going to bear witness against you, they got to be able to look you in the eye and do it in the courtroom. To have a compulsory process for obtaining witnesses in his favor. So I can't just, if I've got witnesses to speak in my favor and I'm on trial for an infamous crime, I got to be able to, I got to have a process whereby I can call those witnesses. That cannot be denied me. And to have the assistance of counsel for his defense. That's like state-offered counsel. If I can't afford an attorney, one will be provided for me at the expense of the court. Seventh Amendment, right to trial by jury, obvious. Eighth Amendment, cruel and unusual punishment. Now, it's worth noting that what cruel and unusual means has morphed over time. What could be considered cruel and unusual to us was not by the standards of that day. Ninth Amendment. Here's where we really get down to business. The enumeration in the Constitution of certain rights, including in the Bill of Rights, because this is part of the Bill of Rights, shall not be construed to deny or disparage others retained by the people. In short, just because we didn't spell out one of your rights in here does not mean it does not exist. And the 10th Amendment. So we talked about why is the federal government so small? Why did the Constitution define such limited powers for Congress and for the presidency and even the Supreme Court? Because the states were meant to be where the action was at. The states were meant to provide their own constitutions, their own rules, and this is twofold. Not only to have a local throat to choke, but also competition. If Florida was so ridiculously mismanaged and oppressive, people could just say, you know what, I'm done, and pack it up and move to Georgia. They had the ability to be mobile. Less mobile in a wagon than in a car, but still. They had the ability to just say, I'm done, I'm out. And that also kept the Florida government in check. South Carolina and North Carolina, West Virginia and Virginia when they split. So very straightforward. Tell me if you see anything ambiguous about this. The powers not delegated to the United States, the federal government, by the Constitution, nor prohibited by it to the states. There are certain things the Constitution said, this is off limit for the states too. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Go ahead and digest that. Let me know if there's anything unclear about that. Anybody? Anything ambiguous at all? The 10th Amendment is the forgotten amendment. The powers defined for the federal government in the Constitution were so defined for a reason. Very good reasons. The framers, the delegates to the Constitutional Convention, they sat in a closed-off room in Philadelphia for months in the summertime. Now, I know Philadelphia is not Dallas, but it still gets pretty hot in an era without air conditioning. And they closed the windows so nobody could see what they were doing. Remember, windows were the air conditioning in. You open a window on this side, and on this side, you get a little breeze. They were hot. They were cranky. They were working in there long into the night, arguing over candlelight. They wanted to be done and gone. They argued over this till they were blue in the face. Very, very tired, but they all wanted to get it right. In fact, going back to Article 5, the two different paths for amending the Constitution. It was Colonel George Mason, 2 days before the Constitution was finished, and on Friday was Constitution Day, September 17th. So that kicked off Constitution Week, the week starting on Constitution Day. That's why I do this at this time every year. But 2 days before it was finally done, Colonel George Mason, one of the delegates, stood up and said, and I'm going to paraphrase him here, I haven't memorized this, but are we really to believe that the federal government in time will not, or will, if it becomes tyrannical, will pass amendments, the kind of amendments necessary to rein itself in? Of course not. So the delegates unanimously adopted the second path, the convention path for Article 5, and everybody was like, oh yeah. Madison's notes record that there was no debate. Everybody saw, oh yeah, we need that. They wrote it in 2 days before the end, September 15th. And then they had the Constitution. And then, sometime later, came the 10th Amendment, which it was implicitly understood at the time. This was argued ad nauseum in the Federalist and Anti-Federalist papers. That's the whole reason there were Anti-Federalist papers, because the Anti-Federalists were saying that this gave the federal government too much power. So this was basically a nod to the Anti-Federalists' argument. And this was put in here, the 10th Amendment was put in here to say, yes, the federal government only has these powers. Everything else is meant to be with the states. So now we'll move on to a few select amendments. The 13th Amendment, of course, is what officially in the Constitution abolished slavery in the United States. I do want to touch on the 3/5 clause here because, especially in the past year or so, we've heard a lot about how the founders only considered black people to be worth 3/5 of a person. It might surprise some people to learn that it was the abolitionists, people who even at the founding were advocating the abolition of slavery. They wanted slaves to be only counted as 3/5 because of the census, which we just went through last year. The slave owners in the slaveholding states, they wanted black slaves to be counted as full people for purposes of congressional districting. The more people you had counted in your district when the census was taken every 10 years, the more seats you got in Congress. So the slave owners, they wanted all their slaves to be counted so they'd get more pro-slavery congressmen. The abolitionists wanted no slaves to be counted to deprive that voting power in the legislature by the slaveholding states. Hence, a compromise was struck, the 3/5 compromise. And it's definitely worth noting that, read the Constitution, read the Pocket Constitution. It never talks about slavery. It never mentions the words slave or slavery in the Constitution. There was already such contention when the Constitution was framed that it was avoided. The text of 3/5 was like Indians not taxed and all other persons, which was slaves. So that set the stage. Unfortunately, it came to civil war anyway, but it set the stage for the abolition of slavery to try to chip away at it. 15th Amendment, voting rights by race. Very close on its heels to provide the newly freed slaves, only men at this time, the right to vote. It's also worth noting that even at the time of the founding, well before the Civil War, in some states, black men and former slaves had the right to vote. That was never denied uniformly across the United States. It was denied uniformly in the South. 16th Amendment, the income tax. I know everybody's favorite thing, right? This is what explicitly authorized the federal government to impose an income tax directly on the people of the United States. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. So prior to this, the Congress had the power to lay and collect taxes, but without being able to directly tax sales transactions or incomes. They had to do it kind of obliquely, and they were much more subject to the state's power in all of this. The 16th Amendment is what allowed Congress to just reach right around the states and say, we're going to do this ourselves, we don't need you. And we're not going to work with you anyway. So, 17th Amendment. This dramatically changed the way the federal government was structured and, most importantly, held accountable. So this was just for the direct election of senators. When this came about, and it was a popular movement, so when we talk about how if enough people think something is a good idea, it can happen through the legal process, this is a case of that, as was prohibition. And then enough people also thought it was a good idea to repeal prohibition some years later. But that's how it's done through the legal process, not by just executive order or judicial fiat. But you would think it's a good idea. Let people vote on their own senators. But consider the system of checks and balances that the nation started out with. We had the legislative branch, the executive branch, and the judicial branch. The legislative branch was broken into the Senate and the House of Representatives. Originally, before the 17th Amendment, the senators, 2 from each state, as we still have today, were voted on and appointed by the state legislatures. Why would that be? Why would the state legislatures get to choose your senators and not you directly? Bob, why shouldn't you be able to just go and vote on your senator? Because you're never going to meet your senator, especially in a state like Texas, or very few people are. Your state legislator, he lives down the street. You can go choke him. Say, why'd you appoint that knucklehead to the Senate? That's why. Local accountability. Especially before you could hop on a plane and go somewhere, you could walk down the street, you could look your state legislator in the eye and say, why did you appoint that bozo to the Senate? The direct election of senators destroyed that, and with it, destroyed the hand that the states, as entities empowered under the 10th Amendment, well, I should say their authority was recognized and protected under the 10th Amendment, but I digress. The states had that power and influence in the federal Congress, because if those knuckleheads the state legislature appointed were being knuckleheads, the state legislature could just recall them and say, never mind, you're done. Okay, we'll appoint some new clown and see how he does. The states had that power. The states had that check and balance over the federal government. With the direct election of senators, where I just go cast my vote for the 2 senators in my state, the state as a semi-sovereign entity is removed from the equation. That is what changed the dynamic between the federal government and the states. Never mind the regulation run amok. The states suddenly no longer had its check on the federal government. So I'm saying this was a bad idea, but I'm also saying it was enacted properly. It was enacted constitutionally, and it should be undone constitutionally, not just because we think it's a bad idea, so let's just stop doing it. This is now Constitution. It's part of the Constitution. And so this is what we must abide by if we're to respect the rule of law, but we can also work to change it. 19th Amendment, women's suffrage. Black men got the right to vote some years before. Women finally got their turn, and women were allowed the right to vote, many of whom voted for me, and I thank you for it. Those are the select amendments. I encourage you to look over all of them. I encourage you to read the whole Constitution. It's only a little over 4,000 words. It's in somewhat antiquated but plain English. I'm gratified that everybody, or at least most everybody, learned something new tonight. That's my aim. I want to close with this thought. If you learn something new, anybody who knows the stuff you learned tonight also learned it at some point. I don't have any magical power which allows me to understand the Constitution. Nobody needs a magical power which allows them to understand the Constitution beyond a brain and an understanding of the English language. So if there's anything in here which has sparked your interest, made you curious, please research it. I don't have a monopoly on that. Neither does the Supreme Court, neither do constitutional law professors or constitutional attorneys. That's the purview of we the people. And likewise, share what you've learned with other people. This stuff is not taught today, and it is desperately needed. Not just because the Constitution is the second most wholly remarkable book in history, but because if you want to uphold the rule of law, you've got to understand the foundation for it. Thank you very much, everybody.